Hi everyone, my name is Amy McGarry.
And I'm Heidi Brown.
And we are both board certified elder law attorneys here in Lee County, Florida. I am the owner and sole attorney at Amy McGarry Law Office in Cape Coral, Florida. I am, besides being board certified by the Florida Bar, I am also licensed in the state of Florida and in the state of Ohio to practice law. I am a member of the Florida Elder Law Committee as well as a board member of the Academy of Florida Elder Law Attorneys.
Like I said, I'm Heidi Brown, and I'm an attorney with Osterhout & McKinney. We have an office in Fort Myers and one in Naples. I am also board certified with elder law, and I'm a member of the elder law section of the Florida Bar, where I serve as the chair for the Medicaid committee.
So today, in our series of topics that we've been talking about, today we're going to talk about the documents and what you need to do to get yourself in order for your finances and health during not only your lifetime, but also when you pass away. So first, let's talk about a will. So many people come into our office and say, well, we need to get a will done for our family so that we know where our assets are going, which is so important. So a will is a written declaration, and in Florida it does need to be written, of how your assets are going to be distributed at death. And we're going to talk about this because it's only going to be transferring probate assets. We do have a separate program that we have done that we have talked about exactly how the probate process works, but today we're talking about the estate planning. But in the will, you need to make sure that you're looking at, for the will, taking care of only probate assets. So these are going to be assets that are not titled jointly with somebody else, do not have a beneficiary on them, as well as they're not titled in a trust. So they would be an asset just titled in your sole name, so that when you pass away, there's nothing that happens to it automatically via contract with the financial institution. So at that point, you also, under your will, want to nominate who you want as your personal representative. In other states, this may be called an executor, but in Florida, we call it a personal representative. So who is going to handle your affairs when you pass away? You may also have minor children, and you want to be able to nominate who will be your guardian for those minor children, for their person and for their property, of who's going to handle things. So the next document we're going to talk about is a trust. A trust would be used in conjunction with a will if somebody needs a trust to do this. Not everybody needs a trust. Everybody can do a trust, but not everybody needs a trust. A trust, again, is a written document where between you and a trustee, who many times is yourself, would be managing the assets during your lifetime and at death. So in a trust, we have three different parties that we're dealing with. We're dealing with the maker of the trust, that is called either a settlor or a grantor, and then the trustee, the person who administers the trust, and the beneficiary of the trust. Many times when the trust is first set up, the person who is the maker of the trust is going to be the settlor, the trustee, and the initial beneficiary all at the same time, wearing different hats of what they're doing. The money, when it is put in what is a typical revocable living trust, is still your money when you put it in that trust. You still use your Social Security number on those assets, and you are able and free to do with that as you please. You can also do a family trust where you and your spouse together can put your assets in there jointly, and then under the trust, when you pass away, would distribute how you want your assets to be distributed when you pass away, as well as who do you want appointed in charge, who would be your successor trustee to do that. Heidi, do you want to talk about some reasons of why somebody would want a trust?
Sure, Amy. One reason, and we don't see a lot of this right now because the estate tax exemptions are so high, might be, this reason would be to lower the tax liability for federal estate taxes. And this is essentially a death tax. Right now, with the exemption levels for a single person being about 12 million, not that many people will qualify. So we don't see these credit shelter trusts as often, but they are still around for high net worth individuals. Another type of trust that we do see a lot is perhaps a special needs trust. And this is a trust that is set up for somebody who is disabled or somebody who is on certain programs for Medicaid. And it's basically either to protect either assets or income from counting against them and making them be disqualified for that particular Medicaid or perhaps even SSI. Another type of trust that we might see, or another reason for a trust might be, let's say you have children who are young or they are young adults and you are afraid that if they inherited $1 million outright that they would spend it foolishly. Well, you could set up a trust that has parameters that states that at certain ages they receive a little bit of the money. Or you could say that the trust can only pay for health, education, maintenance, and support. Sometimes we'll see trusts where it's a second marriage and perhaps they also have a valid prenuptial or postnuptial agreement. And perhaps the person doesn't want all of their assets to go to their spouse. Maybe they want their spouse to be able to use some of the assets. But when that spouse passes away, they want the assets to go back to their side of the family. So for that, you probably would need a trust.
And one last reason that I think is probably one of the biggest reasons I think is, and you sometimes forget about it, is somebody who owns real estate, especially outside of their homestead,
Yes.
especially if that real estate is outside of the state of Florida, so that you don't have a probate triggered in that state as well as in Florida to be able to do that. So, and they're going back on what Heidi was talking about, those special needs trusts. If a parent or grandparent sets up a special needs trust for a beneficiary who is a special needs person on those means-tested government programs, it is so important to plan ahead of time, because if that beneficiary received the money when their parent or grandparent died and with no special needs trust, they need to jump not only quickly through those hoops, but there may be a government payback to that when they pass away. Where if the parent or grandparent sets that up ahead of time with a special needs trust inside of their trust for the beneficiary who is disabled, there is no government payback if it is set up properly when the beneficiary who is the special needs person passes away. So great point, Heidi, of bringing that up.
Oh, one final reason that I just now thought of, you could be like my grandmother who had 11 children. You cannot put all 11 children as beneficiaries of your stock account or your bank account. The financial institution will probably say that their form does not have enough room or there aren't enough character space in the computer software that they use. So if you wanted everything to go equally to all 11 of your children, you would need a trust.
Or even if you don't want them to go equally, because some financial institutions will only let you put beneficiaries on in equal shares. A lot of the banks will only let you do that. So let's talk about other ways to transfer assets besides a will and a trust. So other ways to do that would be joint with rights of survivorship. But there's some caution to that of having joint with rights of survivorship, because if you have a child who is joint with you on an asset and that child gets into financial trouble, their creditors, or even if they file bankruptcy, can come after your asset, including your homestead, if you put them on there. Your homestead property in the state of Florida is protected as to your creditors. If you, because you live there, or even if you went into assisted living or a nursing home, it is still your homestead. If you put a child on that house to try to avoid probate, that could cause some big issues. If that child goes into financial issues, or into creditor issues, because they can come after your house or your bank accounts, whatever you have them on as jointly. You're better off having your child help you out and put them as power of attorney to help you pay bills for those on those bank accounts, but let them inherit the asset through a beneficiary designation, or in the case of a home, the best way to do that always is through the short form version of a summary administration probate, because then that child's going to receive a order from a court that says that house is protected from your creditors. And again, Florida law gives us the protection of homestead property, and most people, that is their largest asset. Is what I tell people: you have a gift from the state of Florida that most other states don't have. Don't blow it. Probate is not the big horrible thing that everybody thinks it is, and summary administrations with just homestead can get through quite quickly. Heidi, do you want to explain what tenancy by the entirety is?
Basically, I just think of it as husband and wife or spouse and spouse property. In order to have this type of property, the couple has to be legally, validly married. If it is a common law marriage, for the most part, Florida does not recognize common law marriage unless they are coming from a common law state and that couple had perfected their status as common law in that previous state. If it is land, typically there will be a deed that indicates that it is owned by husband and wife. But even if it doesn't have the magic words husband and wife, as long as the two people are in fact married, it will be treated as tenancy by the entirety property. Now, tenancy by the entirety property is treated differently than the other type that you will sometimes see, which is called joint tenants with rights of survivorship. In that, in order for a creditor to come after and force a sale or take that property, the creditor has to be a creditor of both spouses, not just one. So let's say the husband has losses due to owning a business and his creditors are coming after him for that. They cannot come after the homestead. They cannot also come after any kind of property or assets that are owned as tenancy by the entirety unless they are also a creditor of the wife.
And you can actually set up financial accounts as tenancy by the entirety, and you actually just have to ask your financial institution to title them that way, because most of the time they're defaulting to joint with rights of survivorship. And if you're married, you get much better protection with tenancy by the entirety. And again, just to touch on, transfer on death beneficiaries is all those financial accounts and life insurance and IRAs. You can put your beneficiaries directly on those accounts by filling out the beneficiary forms. And then at death, it does not go through your will. So again, if you leave one child on as the beneficiary and your will shows that it's supposed to be divided 3 ways, it's only going to go to that one child. So make sure it's what your intent is on how that asset is going to be distributed, because money and death make people do things that you normally wouldn't think, and they do not have to share it. And even if they do want to share it, it could cause them to have to file gift tax returns and hire an accountant to do that. So the simpler way to do it is to just set it up the right way in the way that you want it. So if you have no will or trust, again, the assets can be transferred, as we just previously talked about, with joint tenancy, tenancy by the entirety, or by a beneficiary. If not, they would have to do an intestate probate, where with a probate court and the laws of the state of Florida will dictate how those assets are going. They're not going to go to the state of Florida unless they are in a very, very worst case scenario, which both of us in all of our years of practice have never seen. But they will be going to family members that the law dictates, which may not be your intent of how you want your assets to go. So the next document in estate planning, and I believe is probably one of the most important documents, wouldn't you, Heidi?
Yes, I believe that sometimes the power of attorney document is sometimes more important than a will.
Yes.
Because, if you don't have a will, as long as you would want everything to go to the people who are already named in the Florida law as your heirs, then I guess it's almost like no harm, no foul.
Or you have everything by with beneficiaries on it. There may never be a probate to begin with, especially if you don't own real estate, or if you do, like Heidi said, it's already going to go how default with probate law would state. However, if you become incapacitated and you don't have a valid, durable power of attorney, your family members, it can even be a spouse, is not going to be able to handle anything of yours financially for your benefit. So people say, well, I have joint accounts with my parents, or my bank account is joint with my wife. Why am I worrying about having a power of attorney? Just because that means that they can handle and pay bills out of that or without a power of attorney. But if anybody has to deal with the insurance company, how many times have we ever had a spouse where the insurance is under one spouse's name as the main policy holder, and the other spouse is the one who's calling the insurance company, and they say, well, I can't talk to you, please put your spouse on the phone, and then they'll talk to you. A power of attorney overcomes that. What happens if that spouse who's the main person is incapacitated or is unavailable and you're not able to have that done? What happens if somebody has to sign a contract, including a contract to go into assisted living, home health care, nursing home care? These are so important. I mean, the list goes on and on that we can talk about the importance of having a power of attorney. Your retirement accounts, your pension accounts, dealing with in case you had to deal with a lawsuit. Any of that during your lifetime, if you are unable to handle that for yourself, you need to have a power of attorney. In the state of Florida, the law changed back on October 1st, 2011, when they fully revamped our power of attorney statutes. Any power of attorney signed in Florida prior to October 1st, 2011 is presumed to be valid. Powers of attorney after that date must be signed under the conformities of this new law. What it is stating is you have to have 2 witnesses and a notary on this. Additionally, the powers can no longer be general. We are not allowed to have a general paragraph hitting the highlights of real estate and a bank account, and similar very language that says whatever I can do, my agent can do. That is no longer accepted in the state of Florida. You have to detail out every paragraph of what powers you want your agent to do. They have gotten quite long over the years as we continue to see new powers that we need to come up. Additionally, certain powers have to be initialed. Heidi, do you want to talk about those powers?
Yes. Back in 2011, the legislature signed into law the new power of attorney law, and stated that certain powers must be separately initialed or separately signed. We give them the nickname the superpowers, but really the idea is the legislature and the law felt that people needed to take a minute and think about the awesome power that they're giving to somebody else. And basically these are the powers to give away your assets, your money, the power to create a trust, the power to change beneficiaries on a bank account, the power to change beneficiaries or the way a deed is titled, the power to disclaim, which is where you state you do not want to inherit from somebody else's estate. And with these powers, if they are not separately initialed, they are not effective. So what can happen is the document can still be used, but if, let's say, you needed a special type of trust to apply for Medicaid, then it means your agent under power of attorney They may be able to do your banking and what have you, but they are not able to create this trust. And we then have two alternatives. The first would be to, if you're still competent, you can sign a new power of attorney that states and it has all of the powers, superpowers initialed. If you're no longer competent to sign a power of attorney, then we would have to file for guardianship.
Yeah, and so they're very important in the elder law world that we have most, if not all, of those superpowers initialed, because that really, when we do not, really limits us to the different techniques that we can use to get somebody qualified for Medicaid. As something as simple as Heidi just said, that if their income is over the Medicaid income limit, we need to have that power to do the qualified income trust, especially if the person is not competent or doesn't have a spouse. The only other people who can sign that trust is a power of attorney, the agent with those special powers, or also having a guardian. And the guardianship just will take longer, as well as it costs more, and it could slow down the Medicaid application and qualification. So moving along to healthcare issues, the next one is going to be the Advance Directives for healthcare. There are three main documents that we prepare for healthcare. The first one is what's called a healthcare surrogate, and that's what it is called in Florida. Some other states will call it a healthcare power of attorney. In Florida, the healthcare surrogate is going to be able to make healthcare decisions for you. And if you initial, Florida loves initialing, if you initial two boxes with specific statutory language, that your healthcare surrogate can actually start making those healthcare decisions for you when you're ready for them, even if you're not incapacitated. That helped with a glitch in the law that when they made this change several years ago, because people may have not have been feeling 100%, they were still capacitated, but they wanted their loved one, the one who they nominated as their healthcare surrogate, to be able to make those healthcare decisions for them, but they had no power under the healthcare surrogate designation to be able to do that. So by initialing those paragraphs now, the person can basically hand over that authority for somebody to make that decision, though reminding that while they're capacitated, if they don't like the decision their surrogate made, they can always take it back and have final say. But this document is so important because if you don't have a healthcare surrogate and you need someone to make healthcare decisions for you, Florida does have a catch-all statute called the Healthcare Proxy Statute, except that it is going to dictate who is in charge to make those healthcare decisions for you. It starts with a guardian, which in most cases the guardian would already have authority, but the next step is going to be, is your spouse. Well, maybe somebody has been separated for their spouse for years, but they stayed married because of health insurance reasons or for other reasons, and that person now is going to be the person who has to step forward to make your healthcare decisions for you. May not be the person that you really want to be making healthcare decisions for you. Or maybe you're in a bad marriage and your marriage hasn't ended yet and you don't want that person to be making healthcare decisions for you. The next person after your spouse would be the majority of your adult children. Again, may not be the people, or your kids all can't get along. So, and the list will go on how the law dictates who makes these decisions. Again, this is the importance of you being able to choose who you want to make those healthcare decisions for you. And when you look at nominating who you want as your agent for your power of attorney, or your trustee, or your healthcare surrogate, look to the people that you trust the most, okay, especially and who's organized, especially when it comes to handling finances. And for the healthcare surrogate, who is the best that you're looking at to handle in crisis situations? You don't want the person who is just going to lose it in a hospital setting to be making your healthcare decisions for you.
And make sure that these people actually want to serve as your fiduciary.
How do you want to talk about a living will?
Sure, Amy. A living will is different than a last will and testament that Amy already talked about. But basically, a living will just talks about what do you want to have happen when you're at the end of your life, or you're terminal, or you're in a persistent vegetative state. And basically what I mean by what do you want to have happen is, do you want to continue receiving treatment? Do you want to continue to be on artificial life support? And this assumes that you're not able to communicate. Because if you can communicate, we can ask you, do you want to stay on your feeding tube? Do you want to receive water? Do you want to receive any kind of further medical treatment? And like I said, this only kicks in if you're terminal, or you have a persistent vegetative state, or you're in an end-stage condition. And basically, 2 doctors have to certify that you're at that state. It can also include withdrawing respiration and nutrition and hydration.
This is so different than a do not resuscitate
Yes.
order. We'll come back to HIPAA in a second, but Heidi and I probably all the time get the question of, well, what's the difference between the living will and a do not resuscitate order? Well, the first one is we as attorneys cannot prepare a do not resuscitate order. Only a doctor or physician is the one who can sign a do not resuscitate order. That is signed by the physician and the patient, or the patient's healthcare surrogate or power of attorney who has authority to do that. And under that is stating that if you go into cardiac or pulmonary arrest, that you do not want to be resuscitated back, that you would just basically no emergency services at that time. It has to be on what they call a canary yellow form. If it is printed on any other color, including white, it is not a valid document.
Correct.
This is so important. You will see people that will have these posted on their refrigerator. It is important to have that document available if you have it. If you do have one, and you make sure you also have, because on the form itself has a small version of it on a card that you can put in your wallet. Again, make sure it's on that yellow paper, but make sure you put it in your wallet, so if you're ever in a car accident or walking or something happens, the emergency medical will know where to look for that paper. So again, difference between the living will and a do not resuscitate order. The HIPAA authorization, which I just noticed I misspelled, it's HIPAA. This is federal law that will tell you that you are nominating who can have access to your medical records. So this is important because not only do you want most likely your healthcare surrogates to be able to have access, but maybe you want your other family members or a local friend who's here, especially if you don't have family local, who will be able to talk to your doctors, or if you go into the hospital, will be able to get past the front desk to be able to find out what's going on with you. This will be blanketed across all medical facilities and doctors, as well as this document can go past your date of death. So this is one of these few documents that can go past death, where the power of attorney and the healthcare surrogate end at death. This one can go past death. And the importance of having it go past death is if you died and your family needs copies of your medical records for insurance purposes, or God forbid that you passed away under negligence or possible negligence, and somebody needs copies of those medical records, they cannot get those without a court order unless they have a HIPAA authorization that went past death. So again, we've had to open probates up for the sole purpose of getting medical records, which is very costly. That if the person just had a HIPAA authorization, that would have saved quite a bit of money for the family to be able to get those medical records. So what happens if you don't have all this? Well, we're quickly going to let you know if you don't have a power of attorney or those healthcare directives, you may be forced into what's called a guardianship. This is when you file, you have to have somebody petition that states that the loved one is incapacitated to some extent, if not the whole extent, to handle their own affairs. This, again, can be very costly because you're looking just between filing fees and examination fees and then attorney fees and everything. You're looking probably $3,000 to $5,000 minimum to even get one started. And that is, the $3,000 is probably very low, okay? even if you have the documents, there are rare occasions where a guardian still should need to be filed. But then we always try to back out and get the incapacity order under the incapacity part of the guardianship so that we can go back in using the power of attorney. But sometimes we have to stop a person's right to do things on their own, such as the right to contract or get out credit cards or give money to fake charities or to bad people, or maybe the few times that we've had to, the power of attorney is the bad person and we have to oust them out of there. So you can do what's called a pre-need guardian that states that if you are ever under guardianship, this is who you want. And the court will look to that first, and as long as that person is appropriate and is qualified to serve, the court normally will appoint that person as the guardian.
And not a felon.
And not a felon, yes. You cannot be a felon to serve as a personal representative in a probate or as a guardian. Determination of incapacity part of the guardianship is where 3 independent committee members who are either a physician or a psychologist or psychiatrist or a nurse practitioner will come out and meet with the individual independently and write a report back to the court. Their fees for coming to do this are borne on the person who is incapacitated, as well as all the filing fees, as long as the lawsuit or as long as the guardianship wasn't brought based on bad faith, that all the costs associated with the guardianship are going to be borne on the incapacitated person. So it does tend to drain their money quickly if need be, which is going back to you may pay a little bit in the beginning to get all the estate planning done to save a lot at the end so that you don't have to go into guardianship. So then the court will have a hearing to determine what rights, if any, need to be removed for the incapacitated person. And then a guardian is going to be appointed. Again, they'll look to that pre-need guardian and then family members. And if they cannot find appropriate family members or the family fights too much, the court will most likely appoint a professional guardian to be the guardian over the person and or property of the incapacitated person to do this. The court is going to continue their involvement with this person until they are restored capacity, or that when the person passes away and all paperwork and accountings have been filed and approved by the court. Because annually the court wants to know how somebody's money is being spent and also how their health is being taken care of. So this finishes our kind of making your important preparation and making sure everything is in order for you. And we ask you to look forward to additional videos that will be coming out in the future by Heidi and I. Have a great day.
Goodbye.